So thank you all for joining me. My name is Emily Kile. We're going to talk today about Arizona Medicaid, Arizona long-term care, which we call ALTCS in Arizona. I want to be really clear that ALTCS is one of the most complicated areas of the law, and I am not in any way trying to give you legal advice about how to do planning on your own. Everybody's circumstances will be extremely different, and every rule has an exception, and your circumstances will be different today than they will be next month, and the rules may have changed by then. So please understand that I'm trying to give you basic information about how the program works. I have two sort of mini case studies that I put together just to give you some ideas about how we go about retaining assets and still getting help from the state to pay for long-term care. But please take it for what it is, which is a 1-hour webinar on a topic that I could do an entire probably week-long conference on, and where everybody's circumstances are so incredibly different. So again, thank you for joining. And I look forward to this. It is probably going to be fairly dense, and so I apologize for that. I haven't figured out a great way to make it lively and exciting to talk about Medicaid, but it's so important to understand kind of what the basics are so that you have some idea as to when you might want to start planning or what to do to plan, or if you're already in a circumstance in which long-term care services are needed, what to anticipate. So to kind of start with the basics, we have entitlement benefits, we have needs-based benefits, we have benefits that provide actual cash to the beneficiary, and we have benefits that provide medical services without there being cash provided to the beneficiary. So you may be familiar with Social Security disability benefits, and that is a benefit when somebody has worked enough quarters, and therefore they're going to be, then they become disabled, they're going to be eligible for Social Security disability, which in some ways I think of as early retirement benefits. So you paid in and you get something out. That is not impacted by how much money you have in the bank. That's impacted by your ability to work and how much earned income you have. We have SSI benefits, supplemental security income, and that would be for folks who were not able to work, maybe somebody who was developmentally disabled or became injured at a young age and was not able to work and is disabled. And then those folks are going to get some income from Social Security, and that program is absolutely based on how much you have in assets as well as the income coming in. So that's a program where you can't have more than $2,000 of countable resources. Then we have Medicare, which you may be familiar with if you become retired, have end-stage renal disease, or 24 months after the person would start to receive Social Security disability benefits, they would be eligible for Medicare. And then Medicaid, which we call ALTCS, the Arizona Healthcare Cost Containment System, and in our presentation today, one facet of that, which is ALTCS, which is the long-term care piece, again, is going to have income and asset requirements in order for somebody to be eligible for those benefits. So it's no surprise, long-term care is not free. These are kind of the ways that most people are going to end up paying for that kind of care. And so obviously, you know, paying out of your own pocket, or maybe you have long-term care insurance and that will pay either some or all of your long-term care costs, maybe for some short period of time, maybe forever, depending on what that policy looks like. Medicare does not cover custodial care. So if you've been in a hospital and you're then discharged to a nursing home to get some rehab, whether that's speech therapy or physical therapy or occupational therapy, then Medicare is going to cover some of that rehab center, but not if we have somebody, for example, who has Alzheimer's and just needs to go into a facility, an assisted living center for what we would call custodial care, where we don't anticipate an improvement in their condition. And then, of course, we have ALTCS, which we're going to talk about today. And then there's also some benefits through the Veterans Administration if the person was a veteran who served active duty during some wartime period, even though they weren't in the theater of war, and that they meet certain criteria, or they're the surviving spouse of a veteran who met that criteria. So that would be a whole nother presentation, but there are some benefits available to veterans. So if you are a veteran or you know somebody who is a veteran, that may be something that they would want to look into in order to get some benefits. So in general, what is ALTCS? And in lots of states, it's just called Medicaid, and every state has a completely different program. They may cover different things. They may have different eligibility criteria. Their process for becoming, for applying for benefits will be very different. Which department within the government in that state manages those benefits is going to be different. Again, ours is called ALTCS. Maybe it's Medi-Cal in California, and maybe it's just called Medicaid if it's in some other state. So this is a program that is in part funded with federal money and in part funded with state money. And its purpose is to provide a net underneath us for people who are medically needy and have limited financial resources, and they need those long-term care services. Even Medicaid typically is not free. So you may end up having to pay some share of cost to that facility, depending on whether you're single and what your income is, or you're married and your spouse needs to go in for care, depending on what that person's income is or what your income is, to determine whether you also have to pay some amount to that provider to provide those services. People always say, well, I don't want to give my money to the state. I want to protect it from the state. Remember that ALTCS is a service where that is the state, is paying for your care. They're providing money to help you. You're not paying necessarily the state for the services. They're helping to cover the shortfall in cost. And it will never provide services at home 24 hours a day, 7 days a week. So on average, when we have folks at home, we see that the program will cover maybe 20, 30, 40 hours a week of in-home care. So it can be substantial. But if your loved one needs 24-hour care, they cannot be left alone. They need awake staff. You may get services from ALTCS at home and still need to pay privately for additional care services. So I think also people think of ALTCS as a nursing home benefit, but we have a great Medicaid program. I think we probably have one of the best in the country in that it covers group homes, it covers assisted living centers, it covers adult day services, memory care centers, and then it's also going to provide typically coverage for deductibles and copay over and above what maybe the Medicare or the private insurance is paying. And you can absolutely keep your private insurance, and we would want you to, even if the person is on ALTCS benefits. That's a deduction from their income. That's perfectly fine. And then they can keep their providers that they have. They can get those extra services that otherwise somebody would have to pay for. So I can't think of a circumstance where we told somebody to stop paying for that extra private insurance. And of course, you would keep your Medicare. If that person is eligible for Medicare, those services would stay in place and would remain to be the primary payer source if the person needed, for example, hospitalizations. Unfortunately, there's a lot that's not covered by the ALTCS program. So the person who is in need of benefits typically will get something called a personal needs allowance, which is about $115 a month that they get to keep from their income if they're inside a facility rather than living at home. And they would have to use those funds to cover things like hearing aids or eyeglasses, podiatry or dental services that are not related to health, so to speak. And also, ALTCS pays for a shared room in a facility, not a single room. So if the person wants to be in their own private room, somebody else, not the state, is going to have to pay for that private room service for that person to be able to be alone in the room. So before I get into the eligibility criteria on the, when you apply, it's important to understand that lots of times people ask me, do I have to be, or does my mom or my dad or my brother or my sister or whoever they're applying for, do they need to be a resident of Arizona? And the answer is what the manual says, the access manual, is that you have an intent to reside in Arizona, an intent to stay here. So from the minute that person gets off the plane or out of the car, as long as their intent is to stay in Arizona, even if they don't have an Arizona driver's license, even if they're not registered to vote in Arizona, that should not be a hurdle to eligibility. They have to be legally in the country in order to get services and have a social security number. And then you have to apply for any benefits the person may be eligible for that would offset medical or long-term care costs. So if they may be eligible for veterans benefits, for example, then you would need to apply for those benefits because that may decrease the amount that the state of Arizona has to pay. And so they want you to apply for all of those benefits. Again, even if you're just going to get denied because you don't meet the criteria, still need to apply for those veterans benefits. And you can't say that you're not going to take certain income that is available to you without there being some kind of an impact on when the person may be eligible for the benefits. So these are really the three criteria that I think about when I'm thinking about eligibility. The person's here, I'm talking to them, or I'm talking to their family member, and I know they're in Arizona. And we want to make sure, again, that they're legally in the country in order to get benefits. But these are the three kind of assessments that we're looking at and that we're going to talk about today. The medical piece, the person has to meet a pretty high level of medical need, which we'll talk about in just a moment, in order to qualify. And obviously, I'm not a doctor or a nurse, I'm an attorney. So I need to rely on the family to help me make sure that that person's going to meet the criteria, maybe review medical records, and we're going to talk about maybe having you go and do a private assessment with the Medicaid office, which is free, before we start dealing with the finances if we're concerned that that person might not meet that eligibility criteria. There's an income limit, which we're going to talk about, and then there's an asset limit. And so we're going to talk about each one of these categories to help you understand what the criteria are in order to be eligible for benefits. So let's start with the medical criteria. As I said, it's a pretty high level. It's basically that the person requires an institutional level of care. And ALTCS calls this the PASS, the pre-admission screening tool. And what will happen is that an ALTCS assessor will schedule a time to call or FaceTime or Zoom, and we'll have a whole series of questions to go through their PASS assessment. And they're going to ask all kinds of questions about what that person can and can't do. And we're really talking about functional, like a functional assessment. So it's cognitive, and it's also, can they do their activities of daily living? And again, do they need that institutional level of care? So if the person is completely independent in everything, it's just that you don't feel that they're safe at home anymore, that's probably not enough to meet the eligibility criteria. If the person has a diagnosis of Alzheimer's or a dementia, you're going to want to make sure that you have that in writing from a neurologist to show that they meet that criteria, because they're going to get about a third of the points that they need. You get scored on a point system, and they're going to get about a third of those points just from that diagnosis if it's from a neurologist. While they're interested in things like meal preparation, they're mostly interested in, can they physically feed themselves? Can they get the fork to their mouth? Do they need help with that? Are they on a feeding tube? Are they cognizant of where they live, of who their family is, of what's going on in the world? Do they need help in the bathroom? Do they need a standby assist in the shower, or actually somebody to bathe them? So I like to think of it as kind of three separate categories. Can you do it independently? Do you need a little bit of help, or can you not do it at all without assistance? And again, if somebody is concerned because we're not sure whether they're going to meet that criteria, you can call the ALTCS office and ask them to set up what they call a private pass, that pre-admission screening tool. And then regardless of having filed an application, regardless of whether they would meet the financial criteria, you can find out whether they're going to be, they're going to get assessed in such a way that they would meet the medical criteria for ALTCS eligibility. So we're next going to talk about the income on the financial level. So ALTCS says you have to have, the applicant has to have income less than 300% of the federal poverty limit, which is in 2020 is $2,349 a month of gross income. Now, I say it that way because it's really important to understand that's gross income. That's before your deductions for Medicare, before taxes are taken out if somebody has a pension, and we're only looking at income that's from a third-party source. So if you get income from a pension, you get income from your Social Security, you get income from the VA, that's the kind of income we're looking at. We're not looking at dividends and interest payments from your investments. And as I said, the person can only have $2,000. So the likelihood that at the time of application they even have any dividends or interest is going to be really, really small. And again, we're looking at the applicant's income. So if we have a married couple, we first look at the applicant's income. And if their income is below that $2,349 gross income per month, then we have to know what the spouse's income is, but it won't impact eligibility for their spouse who needs the ALTCS benefits. If the spouse who needs the ALTCS benefits is their income is more than $2,349, then we say, okay, we look at twice $2,349 and we say, is the combined income less than $4,698? So if the combined income is less, the person will still qualify without having to do anything else. So that often is the case, and so we don't have to worry about income as a problem for eligibility. But if the income is too high, and I mean by 1 penny, if your income is too high by either of the tests that I just told you about, then we are required to create a Miller Trust, sometimes called an income-only trust. It is very important to me that you understand that that is not optional. If your income is too high and you don't do an income-only trust or a Miller Trust, you cannot qualify for ALTCS. So sometimes people will say, well, I'd like to create an income-only trust or a Miller Trust because I have too much in assets. It's not about assets. It's only about income if the income is too high. And we don't have a choice. It's a requirement in order to become eligible. All ALTCS will tell us is you're eligible or you're not eligible. There's no in between. It's a one or it's the other. So it's called a Miller Trust because that was the case that allows us to do this. I prefer to call them an income-only trust because I think it's less confusing because it's only about income. It's not about anything else except for income. And so I've kind of given you an example. So if we have a single applicant and their income is too high for that person, then we're going to say, okay, we need to create this new trust. We're going to have all of the income of the applicant go into this new trust that we've created. We draft a trust document, you open a new bank account, the money goes in there, and then we have a whole bunch of forms that ALTCS requires that we complete that explains to you how the money comes back out of the trust each month, how it is that you're going to manage those funds. So I saw that there was a question about how long does it take to set up a Miller Trust. So in our office, we can usually turn those around within about a week or two, but there are some complicating factors. So drafting the trust, and then that's kind of the easy part for me. The harder part is we have to fill out these other forms that are the budget for how you're going to use the money in the income only trust, making sure you're counseled correctly, because if you do it wrong, the person will become ineligible for benefits. We don't want that to happen. You have to set up a bank account, and we need somebody who has the authority to actually sign the trust document. So if your spouse, I'll use them as an example, your spouse has dementia and they no longer are competent to sign documents, and they don't have a financial power of attorney or any other document that gives anybody the authority to manage their income, that's a problem, right? We need somebody who has the authority to do that. We might end up having to go to court and get somebody appointed for the limited purpose of signing the income only trust, being appointed to be the trustee, and being able to redirect the income into that income only trust. So while I'm not going to talk today about estate planning documents, the financial power of attorney is like the most crucial document when we're doing any kind of planning for ALTCS purposes, because that's what gives us authority to do transfers that we're going to talk about in a little bit, about asset changes. That's what allows us to draft an income only trust and appoint a trustee for that purpose and redirect the income. And you might be thinking to yourself, well, I'm the rep payee through Social Security, so I could redirect income wherever I want it to go. That may be the case, but I need a new account set up in the name of the trust, and the bank is going to need somebody who has the authority to sign the trust document and appoint themselves as the trustee if the person is no longer competent in order to be able to do that. So one of the other questions, is there a cost to setting up an income only trust? So I am not here to talk about our fees. Anybody can always call our office and ask what the cost for that is. Yes, there is a cost for us to draft the trust document and help walk you through those other documents that are required. And you can always feel free to call our office to determine what that might look like. And with banks these days, you will have to make an appointment with the bank so that they know you're coming. And oftentimes they will ask you to email or fax them the trust in advance. The trust gets set up under the Social Security number of the person whose income we're talking about for the purpose of setting up this income only trust. And again, you cannot put assets in an income only trust or a Miller trust. So if you're over the resource limit, this is not the way you get underneath the resource limit. The manual is very, very clear that you cannot put assets, that is your bank account, into the name of an income only trust or a Miller trust. You can't say I'm over resources by $3,000, so I'll just write a check into the income only trust. The other thing to remember is the money in the income only trust, when that person passes away, the state of Arizona gets to keep what's in there up to the amount that they paid for care. In truth, there should never be more than a month, maybe 2 months worth of income residing in that income only trust, because it should all go in and then it should all have a place to go to come out of the trust each and every month. Doesn't always happen that way. Sometimes money gets stuck in there, as we say, but that's just the general goal. So let's talk about the financial resources and eligibility. The applicant cannot have more than $2,000 of counted resources, whether they are single or they are married. The applicant, I'm not talking about their spouse, I'm talking about the person who's in need of ALTCS benefits. Those assets need to always remain under $2,000 for the rest of the life of that beneficiary, that ALTCS beneficiary. If you are married, the well spouse, the spouse who doesn't need ALTCS benefits, gets to keep half of the total resources up to a maximum of $128,640. So if you had $300,000 of countable resources, the well spouse could keep $128,640 without doing any planning. But of course, then we have an overage, and we're going to talk about some planning ideas for what do we do with what I call the excess money. Although I'm sure none of you think you have excess money. I've never met anybody who said, I have excess money, but that's how ALTCS thinks of it. There's also a minimum though. So if you're a married couple and the person needs ALTCS benefits and you only have $25,000 of counted resources, the well spouse will be able to keep all of that money because the minimum is $25,728. These numbers move just a little tiny bit each year. So I expect it will be a little bit higher come January, but they don't make dramatic jumps in how much you can keep. So there are some assets that are countable and there are some assets that are exempt. So a house that's in Arizona, that's the residence, that's an excluded resource if it is not in a trust. Now, sometimes there's a great reason to put it in a trust because it's a counted resource then. And that may allow a well spouse to keep more money. And all we have to do then later is take the house out of the trust. And voila, we're underneath the resource limit, or we've increased how much that person could keep. But a house in Arizona, if you have a house in a different state, that is not an excluded resource, even if you're using it as your residence. Only one residence, and it has to be within the confines of the state of Arizona. One vehicle is excluded, and all of your personal property is excluded. They don't come in and inventory how many dishes you have, or the necklace that you got from your grandmother, or how many pieces of furniture you have, how many chairs are in your dining room. That stuff doesn't count. That is excluded. Also, if you do irrevocable planning for burial or cremation, meaning that it has no it has no value in terms of it has no cash value, you can't cash it in later, regardless of how much you spent, it is uncounted. So if you pay for a funeral in advance in an irrevocable plan, meaning it has no cash value, you do that at the mortuary, that's totally fine. If it is revocable, then under Arizona rules, it can't be worth more than $1,500, and it has to be segregated out just for the purpose of burial or cremation. So that's why I say it depends, because if it's irrevocable, it doesn't matter how much you spent. If it's revocable, it can't be more than $1,500. So I sort of alluded to this at the beginning, and that is that there could be a cost that has to be paid, the share of cost or the room and board charge. That's an amount that comes from the applicant's income to pay that facility. So let's say that a person is receiving in-home care and their income is not more than $23.49 a month. They're not going to pay for the in-home care provider. ALTCS recognizes that ALTCS doesn't pay for rent, it doesn't pay your mortgage, it doesn't pay your electric bill. So they recognize you still have to basically pay for all of those living expenses, and they're not providing food for you if you're in your own home. If that same single person is living in a facility, a memory care center, a nursing home, a group home, any kind of other setting, and let's say they have income of $2,300 a month, they're going to get to keep, first they're going to have deductions off their gross income for their medical expenses, and then they're going to get to keep their personal needs allowance of approximately $115 a month, and the rest of their income is going to go to the facility where they're residing as their share of cost. And then the state of Arizona is going to pay the difference. ALTCS has contracts with facilities, and so you'd have to choose a facility that has a contract. And so that facility knows how much they're going to get for each person who's on ALTCS. And some of the money is going to come from the person, and some of the money is going to come from the state. If the applicant's income on a married couple is, let's say the applicant's income is $2,300 a month, but the spouse only has like $300 a month of Social Security, that at-home spouse is going to get to keep almost all of their spouse's income who's in the facility, thus reducing what the share of cost is, because ALTCS recognizes that that spouse at home still needs enough money to meet all of their own needs. And so there's going to be some amount of the spouse's income that they still get to keep. All right, we're going to talk about planning. I hope everybody is having a big lunch, so you're going to be energetic to listen, because this is a beautiful picture of what it feels like, I think, when we do planning. Where are we going? Which direction? Why am I doing this? Why did they ask for this? They didn't ask for it before. Why do I have to get it to them tomorrow? Why didn't they give me more notice on this? So this is, it is a complicated process, and so it's important to understand that there are planning opportunities. So a question came up about whether an ALTCS pending patient can still live in the group home, and then when they're approved, is it prorated? That is I think the question is the facility going to get paid to the time of the application while it was pending? Are they going to pay part of that cost? So typically, if a person is in a non-nursing home setting, you would have to have a conversation with the owner of that facility to find out if their contract is such that they will back bill ALTCS from the date of the application. Because otherwise the facility is only going to get paid, whether it's a group home, a large assisted living center, a memory care center. Typically, ALTCS is only going to pay from the date that they finally send the letter of approval out going forward versus retroactive to the date that you actually were approved for benefits when it was pending. So you would definitely want to have that conversation with the facility to understand whether, if you've been paying all along, you're going to get reimbursed for those expenses that were paid, whether you don't have to pay anything but what we anticipate your share of costs to be because the facility is going to get paid back. How do they want to handle that while you are ALTCS pending? Excellent question. And like every other question with ALTCS, the answer is it depends, because a different facility may have a different contract and a different process for that. So these are some planning tools that we use that I'm going to talk a little bit about. But just to give you sort of an overview, because we're going to get more into this single premium immediate annuity, and I don't sell any financial products or make any commission directly or indirectly on these financial products. But they do have a place, I think, in ALTCS planning. Beneficiary deeds are a way to protect real estate from a later estate recovery when that beneficiary passes away, particularly for a single applicant, but even for a married couple. And we're going to talk a little bit about the estate recovery rules when an applicant passes away. Transfers between spouses do not impact eligibility. There's no transfer penalty or waiting period. It might be that the person is still not eligible because, unlike the income where we only looked at the applicant's income, and if they met it, we don't have to look at the spouse's income. For assets, we look at any asset that's in the name of the well spouse, the ill spouse, or a trust for the benefit of either one of those people. We can, of course, do purchases for the applicant. We talked about burial arrangement. We're going to talk a little bit about gifts to family members or others. And we have probably done a handful of divorces in our office when the well spouse, when there was a premarital agreement that existed prior, or the well spouse may be coming into an inheritance that's large. And so whether they stay married for emotional reasons, but they are divorced legally, that's something that may need to be considered depending on how the assets were structured. Okay, so I'm not sure I can say this enough. Every rule has an exception. So please, please, please be careful about what you do without guidance and understanding the consequences. You know, whether you're paying for something that seems totally legitimate, like a grandchild or a child's education or a medical expense for somebody else, it may impact when the person later may be eligible for ALTCS. Adding somebody to the deed to your house because it seemed easier than doing a transfer or a beneficiary deed may also have an impact on eligibility. It may be positive or it may be negative, and pretty much there's a solution to almost every issue that comes in. We have to figure out what it is so that we can make sure that we can answer whatever that question is and see whether we can help to make sure that that person can still be eligible for benefits. So if your person is no longer going to be able to reside at home, you want to make sure that you know that where they're going is going to accept ALTCS when you're ready for that. And if the person is going to receive services at home, you also need to make sure you've contracted with a home care agency that will accept ALTCS as payment. So these are the 3 questions that we recommend people ask when they're touring facilities, when they're trying to figure out where placement is going to be appropriate. Are they contracted with ALTCS? Do you have to privately pay for some period of time before the person goes on ALTCS benefits? And is there an extra fee for that person to be in a private room? So as to question number 2, that could be that they don't require you to privately pay at all. And if you're eligible for benefits, you can move in. As with the last question, it may be that they say, if you're pending ALTCS, we're okay with that, and we'll just back bill ALTCS when the time comes. They may say, though, you need to pay privately for 6 months before we'll allow the person to roll on to ALTCS because their reimbursement rate is much lower for somebody who's on ALTCS versus somebody who is not on ALTCS. And as I said, ALTCS traditionally pays on a shared room rate. So if the person is going to be in a private room, there may be an extra fee for that person to be in a room by themselves. So this is sort of my first case study, and it's very sort of straightforward-ish. We get lots of very interesting situations with clients when we meet with them. But in this instance, I have set this up that we have a single person. They have 2 kids. That person owns a house, and one of the daughters lives with this individual. He has $15,000 in savings, $50,000 in an IRA. He has a term life insurance policy and about $200,000 in investments. And so we're trying to put the pieces together as to what are we going to do with these funds. So as we're exploring what are we going to do, we also have to ask, does anybody have the authority to make the transfers that may need to be made in order to have that person be eligible for benefits? And if the ALTCS applicant is no longer competent, and let's say the daughter is the agent under the power of attorney, does the power of attorney document allow the agent to make gifts to themselves? Can we even do that? Do they have the authority to do that? And if we have assets in a trust, who's the trustee? And so if it's the incapacitated person, how does the next person become the trustee? Do we need 1 doctor's letter, 2 doctor's letter, a committee of the family? What do we need in order to have somebody step in? So if we need to, for example, transfer the house out of the trust, so it's not a counted resource anymore, that we can go ahead and do that. And with every rule, there's an exception. So for example, in the manual, there are these exceptions for house transfers. So this is directly cut and pasted from the Access manual. So you can see, for example, there's no impact on eligibility if we transfer the house to the customer spouse. As I said, it doesn't impact eligibility to transfer assets. And it isn't a judgment call. ALTCS won't call and yell at you for doing transfers, even if they impact eligibility. All they can say is, you're eligible, you're not eligible, you'll be eligible on this date. That's all they say. There's no letter that comes out that's mean or nasty and says you're a terrible person and you should never have done that. It doesn't work like that. There are also these other exceptions. You can make a transfer to the child, to the customer's child or stepchild if they're under 21. I have only done this once in all the years that I've been doing ALTCS planning, because typically the folks who are applying for are much older and their children are much older. But I had a younger person who had early onset dementia, and she owned a house. And so we were able to transfer the house to the child and save the house from estate recovery. It's where the family was living. And so we knew that the house would be protected and this person could still become eligible. We also have this, what I call the caregiver child exception. So we have a customer's child or stepchild of any age that lived in the house for at least 2 years before the date that the customer became institutionalized, meaning that they couldn't live there anymore and went to an institutional level of care, and where that same child or stepchild provided care that basically meant that they didn't have to go onto ALTCS benefits. And of course, we have to provide proof and the doctor's letter and a diagnosis and a letter from the child or stepchild as to the services that were provided, but that's another option without impacting eligibility. You might have a customer sibling who has an equity interest in the house and lived there for at least a year before the customer ended up needing ALTCS benefits. Or we might have a child or stepchild who has a qualifying disability. So maybe there's a 60-year-old son who's on Social Security disability benefits, and we can do a transfer of the house to that person because they qualify under this exception. So this is just an example. When I say to you there's an exception for every rule, I am not kidding. There is an exception for every single rule. So let's now look at some of the planning options. So you can buy things, as I talked about. You can prepay for the funeral or cremation if it's irrevocable, any amount. If it's under $1,500, completely fine. But you can buy other things. You can buy a new TV for the customer if they need a new TV. You can buy them clothing. You can have them get a new computer. Maybe they like to look at magazines. Whatever is going to suit the needs of the customer or the spouse can decrease the assets so that they can meet the eligibility criteria. So I talked about transfers. So if you, the assets again were that life insurance, that's a term policy. Because a term policy has no cash value, it has no value. It could be $1 million term policy and it doesn't matter for ALTCS purposes. They don't care what the death benefit is, only if you could cash it in, what could you get for it? There was an IRA and you want to think about, well, what are the tax consequences to cashing out that IRA? And is the tax going to override what you're going to save from being on ALTCS benefits? And the way the transfer penalty works is, if the person has $215,000 in savings and investments, remember in my example, $15,000 in a savings account, $200,000 in investments. We take the total of that, we divide it by what the state tells us the divisor is in the county. In Maricopa County, it's $7,204.78, and that leads to this 29.84 number. That means that if the daughter transfers the money or the dad transfers the money to the daughters and they immediately apply for benefits, and he meets the other criteria for income and medical, the state will say he is not eligible right now for the long-term care piece in 29.84 months, which is almost 30 months. We will go ahead and he'll be eligible, assuming nothing changes in that time period. You have to disclose transfers that happened within 60 months of the date of the application. So they could do this transfer and they wait 30 months. They don't have to wait 60 months. The transfer penalty does not start until you meet all the eligibility criteria and you have applied. So if you do the transfer now and you wait a year to apply, you still have a 29.84 month waiting period. You haven't started your transfer penalty yet. Your waiting period for benefits. In my example, if the out-of-pocket expenses are $3,000 a month, even if they're $4,000 but they have $1,000 a month of income, we would say they have $3,000 a month that they would have to use principal of their money. So you would spend approximately $90,000 on care, and in that 29-month period, 29 times 3,000, but you would save about $125,000. So when I say that making gifts has an impact on eligibility, it does. The question is the impact good? Is it a good impact in terms of you're going to still be able to save some money? Or is it negative? Are you going to have to wait more than 60 months? In which case you would wait 60 months before you would want to apply. This transfer applies to a transfer in any way where the customer is and the spouse are no longer beneficiaries. So if you put this money in an irrevocable trust, but mom and dad who are applying for benefits are still the beneficiaries of that trust, you haven't made a transfer. It's still their money. If you transfer it to an irrevocable trust and mom and dad are not the beneficiaries of the trust, you've made a transfer as if you had transferred it individually to anybody, whether you gave it to charity or you gave it to your children. So the impact of that kind of a trust, it doesn't change anything. And if the assets are titled in the family revocable trust, they're counted resources. And so what the transfer penalty is where mom and dad, the applicant and the spouse, no longer basically have rights to the money. And that's a transfer regardless of where the money ends up. I think a lot of times people think they can just transfer the money to a trust for mom and dad and now it won't be counted anymore. And it just doesn't work like that. So a question is, are the assets in a special needs trust counted as resources? And the answer is no. That's the joy of a special needs trust. So that's a trust created for an individual under the age of 65. If it's with the beneficiary's money, so let's say that dad was 62 and he needed these benefits and we transferred the $215,000 into a first party special needs trust, then those are no longer counted resources. That's not a transfer, but that kind of a trust says when dad dies, money left in the trust would have to be paid back to the state of Arizona up to the amount of care that was paid for by the state. But if dad's 70, we can't do a special needs trust for him because he's over the age limit of being over 75 or over 65. But if we have a developmentally disabled child and you through your estate plan have set up a special needs trust for that individual, and so their inherited share goes into the special needs trust, they will absolutely should keep their ALTCS DDD benefits so that the group home or other assisted living center will be paid for. So let's take a quick look at my second case study, which is for a married couple. And I basically gave you the same assets as we had for our single person. But with a married couple, we have a couple of extra choices. So again, the house is excluded if it's not in the trust, if it's not titled to the trust. And as I said, the well spouse can keep half of the assets up to $128,000. If the IRA is in the ill spouse's name, we still are going to have the tax issues when that gets cashed out to go to our well spouse. But in this instance, for a married couple, that excess money of $134,000 could go into something called a single premium immediate annuity. And I'm not here to sell you any financial products at all. There are some criteria that are required in order for the SPIA to work. Has to be purchased from an insurance company, has to have a term certain, so it's not for life expectancy. You have to get monthly payments throughout that term, no balloon or death benefits, and the spouse and then the state of Arizona become the remainder beneficiary up to the amount of care that was paid for. So in this example, if $134,000 went into the annuity for the benefit of the well spouse, the spouse that doesn't need services, that well spouse is going to get back about $5,500 a month for if we set it up for 2 years. They're going to get back all of that money, and then they can set up their accounts to be payable on death to their kids. So if the well spouse dies first, the funds are going to go to the children, and they're not going to end up back with the state of Arizona. I have put this in red. Do not buy a SPIA. It is complicated. It's a planning tool for ALTCS. The timing on when we buy it is crucially important. If it's purchased too early, you get to keep less money. We want to make sure it meets all the bells and whistles in order to make sure it's actually going to work for you. I want you again to understand I am not trying to do planning on a webinar when I haven't had any communication with anybody except through my little chat box on some general questions. I'm just telling you that if you are married, you don't have to spend every penny and when your spouse becomes ill and is in need of ALTCS benefits. There are planning options that we can use so you can preserve money and not end up penniless. The goal is, certainly for a married couple, to ensure that the well spouse maintains as much money as possible and gets as much financial help from the state as possible. And for a single person, that we can preserve assets for all the things that ALTCS doesn't pay for. The application process in general will take 90 days, maybe longer, maybe less, depending on the complexity of your application. You want to make sure, again, a financial power of attorney, I cannot stress how important that document is. We want to make sure somebody has authority to actually sign the application and potentially get documents, get bank statements, get copies of life insurance policies, transfer houses, you know, all of that sort of stuff. So having that power of attorney would be very important so we can do what we need to help you plan. And even if you don't need planning, that you can access the financial information that's needed in order to complete the application. ALTCS generally gives us a whopping 10 days to respond to their request for information. So having all the information when you apply makes much more sense than doing your application and then being in a panic about getting all of the financial documents you need in order to apply for benefits. So when the applicant passes away, there's an estate recovery process. Now, people are really concerned, as they should be, about a lien being placed on the home. The state can only place a lien on the home if the applicant is over 55 and permanently institutionalized, meaning in a nursing home or a hospital for 90 or more days, and where all of these exceptions in red, none of them apply. That is, there's no spouse, there's no child under 21, there's no disabled kid, there's no sibling who had an equity interest in the home, all of those things. So if you're married, your house should be just fine. There should be no estate recovery by the state of Arizona for ALTCS benefits. You should be able to maintain that house and then it's yours. If a house is owned jointly and the other person jointly with rights of survivorship or community property with rights of survivorship, and the well spouse outlives the ill spouse, then the well spouse will end up with the entire property with no lien and they can sell it or do whatever they want. You could also record a beneficiary deed. And unless, again, it was a single applicant who's in a nursing home for 90 or more days or hospital for 90 or more days on ALTCS benefits, there should be no lien that was placed against that property. So it will go to the folks who are listed in the beneficiary deed to receive it. Beneficiary deeds must be recorded during life. They cannot be recorded after everybody is deceased. So you would want to make sure that that would get recorded in a timely fashion in order to make sure that we're actually protecting the property from that later estate recovery. If there are assets only in the applicant's name, a bank account, and nobody else is on it, when that applicant passes away, even if there's a spouse, the state will have a right, probably, potentially, to those funds. There would not be a reason I could think of that we wouldn't have a bank account with a joint owner, even for a single person, to have the daughter or the son or whoever's taking care of that person to be the joint owner. And when the person dies, those funds remain available to the survivors. So please, if you're married, your home, your residence, now if you have a cabin or a second home, those are things we'd have to talk about, but your house should be protected. Unless it's only in your spouse's name, we would then want to see whether we could get a beneficiary deed on it or somehow make sure it doesn't end up through probate, although you'd still probably end up with it and it would still probably be protected. So 2 things I want you to come away with. Yes, there's an exception to every rule. All your situations are different. We're here to help you through the maze, but please understand it is a phenomenal net that is underneath each of us when care is too expensive. I don't want you to have to spend down every penny you have in order to be eligible for ALTCS. We can do things to help you before that happens. So please know that the net is there. I hope that this has been helpful. I know it's super complicated and dense. I see that you have all stuck with me for a whole hour on this, and I'm so grateful. I'm so appreciative of you being involved, and I look forward to the time when we can all be together again and have conversations in real life instead of just on the webinar. There are a couple of questions, so let's see if we can get those answered. The question is, if a bank account has a beneficiary assigned, will that make a difference versus having a joint account? Excellent question. And the answer is either joint or a beneficiary is completely fine. They both will end up with the same the same outcome. That is, the beneficiary will still end up with those funds that are listed on that account to be the beneficiary. So there shouldn't be any state recovery against that account. When a beneficiary who is on ALTCS passes away, the state of Arizona will send a questionnaire. It will actually come from HMS, which is Health Maintenance Systems, which is the recovery unit for ALTCS. And so you would want to make sure you fill out the questionnaire, but basically they're wanting to find out, are there any assets that are not jointly owned and the joint owner is alive, and that there's no surviving spouse or disabled child. So it's a one-page questionnaire, and you would want to fill it out and get it back to HMS so that you can move on with your life and know that the assets are going to be protected. So again, I thank all of you. We will have a link available. You should have received the PowerPoint as a PDF. If you did not, for any reason, please reach out to our office. We're more than happy to provide it to you. And I wish you all the best. And again, thank you so much from the bottom of my heart for being a part of my life and a part of the life of the firm. And I hope that you are doing well, and I look forward to seeing you in real life sometime soon. So thank you so much, and take care.